Good morning again, Your Honors. Good morning. Just for the record, my name is Bethany Stevens, and I'm an Assistant District Attorney in Middlesex. Your Honors, the prosecutor's incorrect belief that he had completed discovery obligations does not warrant a $5,000 monetary punishment. This defendant was never at risk for not receiving a fair trial, and there's no basis to believe that there's a systemic problem in the Middlesex District Attorney's Office requiring the redistribution of approximately 13% of an ADA's salary.
Explain to me why there's no policy or practice that's inconsistent with the ethical obligation of prosecutors.
Well, I would suggest, Your Honor, that the obligation to conduct a reasonable inquiry as required by the rule is driven by the nature and circumstances of the case. That while often the times there are many cases...
And so your office has decided that in district court cases, a reasonable inquiry will not include contacting the police officers to find out if there's any additional information that's necessary.
Absolutely not, Your Honor. Our office actually teaches prosecutors to go beyond the discovery packet, but upon reviewing the information...
Your office actually does what to prosecutors?
Encourages prosecutors and teaches them to go beyond the discovery packet and to reach out. But it depends on...
What evidence is there in the... in your gray brief, you talk about the educational efforts, which are commendatory, that are made by the Middlesex DA's office to educate prosecutors and police prosecutors. Is there evidence of that in the record?
There's not evidence of that in the record. We did make the argument to Justice Singleton in our motion for reconsideration, but we did not offer an evidentiary basis for that. But I would...
So is it, in answer to Justice Cordy's question, is it your view that the problem here, that it is compliant with the rule about making reasonable inquiry, you obtain the police reports, and that if the prosecutor had read the police report and seen the reference to the other report, then he would have gotten that and that would have been given. But what if, you know, as it seems to me entirely possible, that other report hadn't been referenced in the police report? Correct. And so if you're relying totally on whatever the police prosecutor gives you, how are you going to find that?
Well, I would just, again, suggest it's the nature and circumstances of the case. So in a disorderly conduct case where you have the police report and you read the police report and there's no indication that there's any further investigation going on, I would suggest that the prosecutor would be fine to rely on that and to not seek further. I mean, in order to do an inquiry, you need to know what it is about you're inquiring. In this case, it was a unique circumstance in that there was a separate case generated by the defendant making her own complaint that she was the victim in the altercation.
Well, what is the practice in Middlesex? Do the DAs generally say to the police prosecutors every day, have you given me everything, or do they just say nothing?
Well, there isn't a regular practice to just reach out to the police prosecutor, did you give me everything? Because that's not going to turn over anything. I mean, then we would have to compare what I already have with what you have.
Excuse me.
Wait, I don't understand.
Slow down. All right, prosecutor shows up in court that morning, meets with the police prosecutor. Police prosecutor gives him the reports for each of the cases that are on the list. Is that what happens? In certain instances, depending on the origin of the way the complaint comes in. But in this case, the prosecutor had the packet of information that included the 4 pages with the application for complaint. It had the police report that indicated that the victim came into the police station a week after the incident, conveyed that she'd been assaulted a week earlier, and during that time she provided a notarized written statement of her action of the events, a notarized written 2-page statement of her husband who witnessed the event, an information page on the defendant.
Okay, so all that they have, but does the police prosecutor say to does the DA say to the police prosecutor at any time, have you given me everything you have?
No. I mean, the way that we have our practices in place is that we have trainings to ask the police prosecutor to provide the information that they have to us.
It may just be a formality, because I'm sure the police prosecutor in every case would answer, yes, I have, but at least then you would have complied with the rule.
But I would just suggest that there's not that the rule does not necessarily envision a bright line rule that requires in the tens of thousands of cases prosecuted in the district court that the ADA reach out on each and every one and ask this general question without providing a lead. And I would suggest here, I mean, had the prosecutor had the information and realized that this reference in the police report to SP, which is suspect, came to the station and filed a past assault report with this separate case number. This is on Record Appendix 37. The statements along with the past report were forwarded to CID, the Criminal Investigations Department. If he had understood that to mean that there was a case that generated or that there was a separate case generated relevant to this case, he would have sought that information.
Obviously, he either didn't read it or he missed it.
Correct.
So that's clear. But you have to do something, because as Justice Boxford says, if there weren't a reference, the defense would never have gotten this other police report.
Well, I would, without the reference.
They would have known about it maybe from the defendant anyway, but you can imagine other circumstances where the defense wouldn't find out about it.
But certainly, but I would suggest that while the amended rules does have the automatic discovery requirement, and the burden being on the prosecutor to find the discoverable materials, that doesn't mean the defense counsel has no role to play to at least alert the prosecutor. Did you know the defendant made a complaint? Was there any investigation to that?
In this case, I don't think the defense acted properly either. But what are we to say? What should we say that the Commonwealth should be required to do? What should we indicate as a general rule would be the better practice, the practice of which we approve?
That the Commonwealth should seek out further discoverable information, but that needs to be based on some kind of a lead. I mean, if we're going to say that there's a bright line rule that the Commonwealth needs to reach out to all the agencies, then we have to say that in each and every case the Commonwealth should be reaching out to the crime lab and just ensuring that there's nothing there, even though there's no indication in the police report that any evidence has been taken. I'm just suggesting that in this case, the prosecutor, when surprised at the sanction hearing, when defense counsel whipped out the motion and said, here is evidence of no reasonable inquiry, he recognized, I made a mistake. I did have a duty to reach out to the police and find those other police reports, and I'm sorry, I made a mistake in this case. It's a human error.
But he has that duty in every case, and I'm just trying to figure out how we should say that the Commonwealth should carry it out, because I think that asking the police prosecutor every morning, did you give me all the reports, that's just routine and produces nothing, because as I say, the police prosecutor is going to say yes. So, but that would be a reasonable inquiry. So what should we say he should do?
Well, I would suggest that there's no reason to say anything, because there's no evidence that there's any kind of systemic problem within the Middlesex District Attorney's Office. Justice Singleton sits in Cambridge.
I'm not saying that, but I'm saying this goes all across the Commonwealth, and there can be cases where things just fall beneath the cracks.
But that's why the whole point of the discovery process is discover those errors prior to trial, which requires some input from the Commonwealth. I mean, as the reporter's notes recognize, that prosecutors aren't always, I'm sorry?
From the defendant. Don't you mean some input from the defendant?
Right, or first from defense counsel, through this process, so that we can find these errors prior to trial. And this was well before trial that this came to light. The reporter's notes recognize that the prosecutor doesn't always recognize what might be the appropriate material, discoverable information. Obviously, that's not the case in this case. The Commonwealth does not dispute that the Commonwealth had a duty to turn over this police report. But it's not like we were trying to hide the police report such that we should be sanctioned $5,000.
Well, what do you think would have been a reasonable sanction for the judge to impose?
In this case, I don't think any sanction was warranted. I think the prosecutor recognizing the problem and apologizing and recognizing that in the future we learn from our mistakes. We're fallible. Prosecutors are fallible, and we're going to make human errors, and we learn from those mistakes. And there's no reason to believe that the Commonwealth won't learn from those mistakes, that we dig in our heels and regardless.
How many assistant DAs are in the Cambridge District Court on an average day? 1, 2, 3?
In the Cambridge District Court,
Yes.
4 or 5, I believe.
Well, you gave the number of, I think, 3,000 cases a year in Cambridge District Court. If you divide that by 50, you get 60 cases a week. Divide that by 5, you get 12 cases a day. If you've got 4 prosecutors, they're only handling 3 cases a day. That's not overburdened, 3 district court cases a day. That's your own number. That's the number.
I mean, I don't believe that's a correct breakdown. I believe that that's the correct math. I was using
that's a footnote from your brief.
Right, and I got those numbers from the trial court, on average. I don't believe that is an average caseload, but even so, I mean, I think that dictating a bright line rule that needs to be followed in every case would just not be helpful. I mean, it does need to be.
How many cases, just for example, does an ADA in the Cambridge District Court handle on a given day?
When I was an ADA in Cambridge District Court, I handled at least 10 cases a day.
But that's not just new cases. You're talking
correct.
Your old cases that are in progress.
Correct. There's going to be motions to suppress as well as the arraignment.
Now it seems to me that the judge was saying more than just that the Commonwealth had made a mistake. He said, I hereby impose a severe monetary penalty against the Commonwealth because, first, the misconduct by the prosecutor in making a false representation of fact to this court, then failing to promptly correct it, is a serious misconduct. So he's saying a mistake was made, and then there was a failure to correct it. Do you dispute that?
Absolutely, Your Honor. I don't find that there's any basis in the record for that. What happened was the ADA thought he had discharged his discovery obligations, and pursuant to the rule, he filed his certificate of compliance saying that he conducted a reasonable inquiry and provided all the discoverable information. He didn't realize that he had a duty to reach out to the police and provide this other further information.
It's not that he didn't realize he had a duty, it's that he missed the reference. wasn't
Correct, Your Honor. Correct.
Well, those are two different things. One hopes he knew he had a duty.
Well, I'm sorry, and I did misspeak. I think that he didn't that he had duty in this case based on the information provided to him.
How soon after the presentation of the certificate of compliance did the assistant district attorney correct the situation and obtain the other police report and the date of birth?
Well, he didn't. The date of birth at the next hearing, the defense counsel alerted him by moving for sanctions that the date of births were missing. The court gave him 2 weeks to comply, but he actually provided those dates of birth that afternoon. But it wasn't until the actual motion hearing that he was alerted that the defense counsel brought out the report, and that was the first time that he learned that the defendant herself had complained.
My question was, what's the time lag between the time he presented the certificate of compliance and the time that he presented the police report that had been missing?
The police report came up on April 14th, I think.
And he filed the certificate of compliance on January 15th.
But the defendant already had it on April 14th.
He had it well before January 15th.
Right, so it wasn't, the prosecutor didn't have to give it to him, he already had it.
And he received it from the police. I mean, we're saying that the discovery is supposed to be from the Commonwealth. There is absolutely no basis to believe that the Commonwealth was trying to hide anything from the defendant. This was just an error that was made that there's no reason to believe it happens on any kind of systematic basis, and there's no reason to further deplete our limited resources and to punish us for this contact.
Ms. Stevens, I take it there was no specific order in this case for production of discovery materials?
Yes.
There was no order, as there was in the previous case?
Correct.
Now, the Rule 14C talks about sanctions for failure to comply with an order. There's no reference in the rule to failure to comply with the rule itself. Do you take a position that since there was no order in this case, no sanction could be imposed?
I think the case law has interpreted the requirements of the rule for discovery violations to have the effect of an order of a court.
But it's not
Automatic discovery is essentially an order of the court.
Correct, Your Honor. That's how the Commonwealth interprets it. But again, there was no intentional violation of any order.
And so the judge, when the judge said that the Commonwealth's representation that it made a reasonable inquiry concerning discovery was knowingly false, you dispute that?
Yes, Your Honor.
And was made in bad faith?
Absolutely, Your Honor. There was bad faith in discovery context has been defined as taken with the desire to.
You're saying the Commonwealth relied on the police representation that they had supplied everything?
No, actually, I think the prosecutor relied on his review of the materials in the case and believed that there was no further discoverable information out there. Reviewing all that he had statements of all the recipient witnesses to the event, that there was a victim that came into the police department and reported a week-old past assault, that there was no other discoverable information.
If the prosecutor knew that there were records and didn't provide them, that would be knowingly false. But here you're saying that it was not knowingly false because he operated in good faith and thought that he had provided everything.
Absolutely, Your Honor.
Is that the rule that we should apply then? If the prosecutor says that, well, I thought I was operating in good faith, that's the end of it?
Well, I think that bringing these mistakes to the attention of the prosecutor is absolutely helpful because we will correct any errors and learn from those mistakes. But I think also imposing a punishment, imposing a sanction like that, when we're talking about an error that's just a human error, that's not going to make it so that there's never any human errors or errors that occur again. The standard is an ordinary fallible lawyer, and it should be an ordinary fallible prosecutor.
I suppose you wouldn't object, I take it, if... I mean, I don't think there can be any doubt that the prosecutor's conduct was negligent. He negligently missed the reference, and
I would agree,
for
Your
whatever
Honor.
reason didn't find that other report. So a sanction, if you want to use that word, in terms of mandatory training on this issue, you wouldn't disagree with that, would you? I mean, you may say it's unnecessary, but in any event, it's the monetary sanction, and you have arguments about separation of powers, but it's really because your view is monetary sanctions should never be imposed if there hasn't either been intentional misconduct, which you factually dispute, or I take it, I don't know, but if for whatever reason there had been real prejudice to the defendant, I suppose you might.
Correct. I mean, I think the case law has said that, you know, the remedy that should be imposed by the court should be the most narrowly tailored to fit the circumstances of the case. This case certainly doesn't raise any circumstance that requires any kind of monetary sanction, and I would suggest this case doesn't even raise the need for any kind of sanction, even any kind of mandatory training. But if that were to be, if there was evidence in the record that there was, you know, lacking on that point, and that the prosecutor did need some kind of training to prevent this from happening in the future, you know, that might be a sanction that the court could employ. I mean, again, I think there runs into a little bit of a separation of powers, but I don't think that the court is without remedy. This court is.
If I could have the separation of powers, I'm sorry for going over the time. Let us imagine a slightly different circumstance. Let's imagine an ADA carelessly failed to provide an expert report regarding testing, which was actually quite favorable to the defendant. And nobody knew it existed, and the defense counsel went and hired his own expert to conduct that same testing and got that same result, and then later learned there had been a report the testing was unnecessary. Do you think it would have been inappropriate to sanction the Commonwealth for that carelessness by requiring the Commonwealth to pay for the expert?
It very well may be an appropriate sanction, you know, to equitably, you know, exercising the equitable powers of the court to remedy that equity.
But that's not a fine, and that's not a penalty. That's cost.
And there is the authority for a coercive fine to compel compliance, you know, but that is, again, yes, a different story.
Thank you, counsel.
Thank you, Your Honors.
Good morning. Daniel Beck for Ellen Frith.
What order was violated? I know the Commonwealth says that they treat discovery as an order, but when we're talking about fines or anything like that,
The order to make a reasonable inquiry. It's not only an order.
no, we're talking about a court order. It says for violation of an order.
It clearly, Rule 14, the case law is absolutely clear that violations of Rule 14 are to be treated as violations of a court order. Otherwise, the whole point of mandatory discovery would be lost. Defendants would have to file a motion for all the mandatory discovery, get an order from the court for the mandatory discovery, and then it would be violation of a court order. The whole point of the mandatory discovery is to avoid that.
All right, you say in your brief that the DA's office doesn't follow procedures in making inquiry. Now, what evidence is there that the DA's office doesn't make the proper inquiry?
There's an admission by
other than this case.
There's an admission by ADA Bolero, it's at page 71 of the transcript, that they do not make any inquiry in a majority of district court cases. And I suggest that that's even being kind, because it's the very rare case in which they do. The Commonwealth seems to be saying, as far as I can see, that the reasonable inquiry can be no inquiry at all. That's reasonable. Well, that's not what the case law says, and I don't think that's a fair interpretation of the rule.
Well, isn't there inquiry? I mean, presumably the reasonable inquiry is inquiring of the representative of the police department, whose job it is to collect these reports and make them available to the prosecutor. Isn't it reasonable that they go, get the reports? Perhaps they should then review to see if, based on the eyes of a professional, there's something else that needs to be discovered. Why isn't that reasonable inquiry in these circumstances?
Because, first of all, we're not just talking, in this case, we're talking about missing a police report. I can tell the court, I'm actually the supervisor for the bar advocates in that court, and I've gotten reports of all kinds of evidence. Very often statements of defendants, which are not referenced in a police report, sometimes things like store videos of the event itself. It's incredible the things that come up on the trial date, because that's the first time the DAs actually talk to the police officers. If they're going to talk to the police prosecutor, what they have to do is not ask the police prosecutor, do you have everything? They have to ask the police prosecutor, have you spoken to the police involved in this case? And have you asked them whether they have given you everything? That's the problem. The problem is not the communication between the police prosecutor and the DA. It's between the police on the street and the police prosecutor. That's where the information gets lost.
So do I hear you to say then that reasonable inquiry may be the ADA speaking to the police prosecutor, but just speaking to him or her in a different way?
The reason, first of all, I suggest that somebody has to speak to the police on the street and involve the police involved in the case. I suggest that the ADA has to do it somehow. That if he wants to use an agent to do it, whether it be a law student, whether it be a police prosecutor, whether it be another prosecutor, that is entirely up to the prosecutor. But the prosecutor, he or she has to actually cause inquiry to be made by someone that reports back to the prosecutor.
And wait a minute, the arrest is made, say, the night before? Doesn't that sometimes happen? The arrest is made, say, Tuesday night, you come into court Wednesday morning, you get the folders. When is this inquiry? And the officer who made the arrest is home sleeping. When are you supposed to make this inquiry?
It's clearly, the rules say, before the pretrial hearing. Nobody is suggesting that it needs to be, at the arraignment, but it does need to be before the pretrial hearing. That's the whole point of the pretrial hearing. Defendants, for instance, sometimes decide to tender a plea at the pretrial hearing. Well, it's kind of unfair to ask them to tender a plea if there's exculpatory evidence that nobody's asked for that is out there. And the prejudice is not to the defendant in this case. The prejudice is to the defendants in the unknown number of cases in which the evidence isn't discovered.
Mr. Beck, when did you get a copy of your own client's affidavit from the police?
It's not my own client's affidavit. It's the.
I mean the police report. I'm sorry, the police report about your client's.
Before the pretrial hearing, certainly.
But your colloquy very neatly conceals the fact, and I don't see why the defense should be permitted to play a game of gotcha.
Because I knew from my experience, I've been in that course since 1987, as I said, I'm a supervisor. I knew that.
Is that the way to teach the young attorneys that they should hide the ball from the court?
It's not a question of hiding the ball. The point is there is no other way to get this information before a court. If in any given case, if you say.
But the judge asked you directly if you had everything a couple of times, and you very cleverly managed to not answer the question.
Right, and because I didn't want to.
That's the way to proceed in court, and that's the way to teach young lawyers to proceed?
I suggest that it was necessary in this case because there is no other way to show that there is a pattern here. Any given
You
case.
could have shown a pattern by saying they haven't given me everything. Here, I have this report that they didn't give me.
But as a
that shows the pattern very clear. I mean, that you didn't show a pattern here. You just showed that in one case. We don't know anything about a pattern. There's no, as far as other than what you quote from ADA Bolero, so that you didn't show that by hiding the ball on the judge at the time.
As I said, my goal at that point was to change the Commonwealth's policy of not inquiring.
Well, I don't believe that misleading the court is the way to change a policy.
I love to hear suggestions. I don't know how to do it, frankly. The idea, what happens is you confront the Commonwealth. In any given case, they say, oops, fell through the cracks, sorry, no misconduct.
You could have confronted them in open court so the judge would have seen what happened. I think that you were quite disingenuous to not answer the judge's questions with the forthcoming responses.
Well, that may be, and I would apologize for that, but I don't think that changes the issue of the Commonwealth having a policy.
So in this case, you agree that your client was not prejudiced.
Correct.
He did get all of the discovery at some point in time. So what if we said no harm, no foul, and going forward there should be that step where the assistant DA makes clear that they've talked to the arresting police officer? Would that resolve it?
No, because the problem is that if it requires prejudice, there is no incentive for the Commonwealth to inquire. If defendants don't discover the evidence, then it's really no harm, no foul. And if defendants do discover the evidence, well, then they're not prejudiced. The Commonwealth can never be sanctioned on that theory if it requires prejudice in the actual case. a policy that the people who are prejudiced are the ones who don't know they're prejudiced. So the Commonwealth wants to.
Well, so how are they ever going to find out?
Well, the point is, if you punish the Commonwealth for doing it when you know they did it despite the prejudice, presumably they will start inquiring in all cases, and therefore that will solve the problem. In other words, the goal here is to get the Commonwealth to conduct this reasonable inquiry. If they know that if the evidence is discovered, that they have not, and I'm not just saying that they deliberately concealed it, but they deliberately failed to inquire to get it. And if the Commonwealth knows that if evidence pops up later, they'll be in trouble.
Your inquiry of the officer on the street isn't really going to resolve it, because another officer might have another report. I mean, and the officer in the lab might have a report, as you yourself stated. So I don't see that just asking, because ordinarily you will have the one report from the officer on the street. And I don't think that would have even helped you here, because if the Commonwealth had asked the officer who took the victim, in this case, her report, he wouldn't have said anything. Did you file all the reports in your case? Yes, one. I've got it. Okay. That wouldn't have gotten an answer regarding the other officer who took the report from the defendant.
Often,
I'm just trying to work out.
Often the information is something that is in the possession of the police officer on the street.
No, but I'm saying it may not be. Just like in this case, it wouldn't have been.
This is actually slightly unusual. The much more common case is where on the trial day, defense counsel discovers that there are statements by the defendant.
Right. So you ask for continuance, and you usually get one.
Sometimes,
if you need it. But I'm trying to work out a rule that would be reasonable. And what you say, I don't think will get you what you want, because the officer on the street normally in a run-of-the-mill case will file one report, maybe two, not in a murder case, and that's it. And he says, yeah, that's all I did. That's all I know about.
Well, I mean, first of all, again, we're not just talking about police reports. And the question then has to be, and were there any statements made by defendants?
But we're trying to get a resolution, and I don't think that you're helping us, because I don't think, having worked with it for years, that asking the one guy on the street is going to get you the reports that other people may have filed, and this case is a perfect example.
Well, it may not get everything, but it'll certainly get more than we're getting now.
You know, I'd like to ask this. Do you contend that when the ADA indicated that they had complied, that they made a knowingly false statement?
Yes.
Knowingly? That they knew?
They knew they had not inquired, and they claimed they inquired. That is the false statement.
Okay, but my guess is, if the ADA had asked the police prosecutor, did you give me all the reports regarding this? The police prosecutor would have said yes.
Perhaps, but first of all, I'd suggest that that's
and
not...
that would have been an inquiry.
But that's not a reasonable inquiry, I'd suggest. I mean, obviously, asking a police prosecutor is going to get is routine, is going to get the same answer every time. A reasonable inquiry has to be one that's reasonably designed to get all the information.
Okay, but suppose the prosecutor does what you want, calls up the officer on the street, who's very hard to get a hold of because working a second job days probably and sleeping, whatever. But suppose that he or she is reached, and then, but it's some report from the lab that they don't have, and there isn't. I mean.
Well, Martin makes it clear that the Commonwealth has a duty to inquire of the lab as well. I mean, this court actually
I think in this case,
issue.
the reasonable inquiry would have involved the prosecutor calling the lab.
In this case, no, there was nothing at the lab. But well, I mean, if you know that something went to the lab, then
well, of course, if you know it went to the lab, of course you should. I mean, I would hope that any reasonable prosecutor, just like I would have hoped that in this case the prosecutor read the report and would have seen the reference. If there's a reference, the stuff was sent to the lab. Of course, we would hope that there would be an inquiry. But but that isn't the problem, because the defense attorney will see that it went to the lab too.
But well, obviously in Martin that turned out to be a problem. But putting that aside, the point is it's not reasonable to expect a reasonable inquiry should not include the lab in every case.
But your point is, in every case, there's an arresting police officer. So,
correct.
So to make the reasonable inquiry, in every case, the ADA has to talk to the police.
Not necessarily.
That's your position?
Not necessarily directly, but he has to have.
Someone has to.
Somebody has to call. Yes, and I think Kyles v. Whitley.
But there wasn't even an arresting officer in this case.
Again, Kyles v. Whitley makes it clear that you have to talk to anybody who's part of the prosecution team in this case.
Okay, but anybody who's part of the prosecution team in this case wouldn't even get you to the officer who took the report from the defendant.
That's
He
not
wasn't
at all-
part of-
that-
He was not part of the prosecution team in this case.
But it's not clear that I would suggest that it's very likely that the officer who was part of the prosecution team in this case would have known about the other officer's report.
And he
Maybe
stated
yes,
it in
maybe
his own
no.
report. He
Yes,
stated
it's
it.
there.
I mean, it was there.
Right.
It's there, so.
The question is, again, the problem is not finding the report. I never suggested that that was the misconduct. The Commonwealth keeps talking about that as misconduct. The misconduct is not inquiring. He admitted he didn't inquire. He also made it sound like this case slipped through the cracks that ordinarily he inquires, when in fact, as we found out much later, and only when asked a direct question by Judge Singleton, that in a majority of the district court cases, they don't ask. He made it sound like, not that he was following the usual practice and procedure, he made it sound like this case slipped through the cracks.
So what's a knowingly false statement that the prosecutor made?
That he made reasonable inquiry.
He actually said
He signed something that says, after reasonable inquiry, I have essentially turned
That's a
over all
form.
this.
That's a form. The certificate of
Certification.
compliance says that.
But doesn't, I mean...
The
but
fact
isn't-
that
isn't
somebody
this-
submits information, whether it's a form or not, I suggest doesn't excuse false information.
But isn't there a debate here about, I mean, I take it that the Commonwealth's position is, which you disagree with, and maybe correctly so, but I take it that they say in good faith, the way we see the way that district court prosecutions go, in the vast majority of cases, it is a reasonable inquiry to get the package to see whether I need to ask something more of the police prosecutor or somebody else, and that's what we consider to be reasonable inquiry. In this case, through negligence, this particular ADA missed the reference and didn't do it.
Well,
But-
what you're saying is essentially that in many cases, reasonable inquiry is no inquiry at all. And I suggest that that makes a mockery of the requirement of reasonable inquiry. That's both in the case law, as I said, Kyles v. Whitley and that line of cases, and the rule itself. If the Commonwealth is essentially saying that reasonable inquiry in a majority of district court cases is no inquiry at all. How that can be, so I don't know what the purpose of even having that, if that's the position, if the court takes that position, then there's no point in even having that in the rule, and and I suggest that it violates constitutional rights. Kyles v. Whitley does not say, in cases that are serious you have to do it. Kyles v. Whitley makes it clear there is a duty of inquiry, and it doesn't limit it to superior court cases.
Thank you, counsel.
Thank
Your
you.
time is up.
SJC-10627, Commonwealth versus Earl.
Morning, counsel.